Default bail, also known as statutory bail or compulsive bail, is a fundamental right granted to an accused person under Clause A of the first proviso to Section 167 Clause 2 of CRPC. This provision has been replaced by Section 187 Clause 3 of the Bharatiya Nagarik Suraksha Sanhita. The Supreme Court, in Bikramjit Singh's case, affirmed that this right is not merely statutory but fundamental. Under Section 187 Clause 3 of the Sanhita, a magistrate may authorize detention beyond the initial 15-day period if adequate grounds exist. However, the total detention period cannot exceed 90 days for offences punishable with death, imprisonment for life, or imprisonment for a term of 10 years or more, and 60 days for all other offences. Upon expiry of these periods, the accused must be released on bail if they are prepared to furnish the bail bonds. The concept of default bail stems from the urgency required in investigations. Investigating agencies must complete their work within the stipulated period, failing which an indefeasible right accrues to the accused for release on bail. This right arises from the investigating agency's default in completing the investigation within the prescribed time frame. The Sanhita introduces a significant change in the wording of the provision. While the CRPC applied the 90-day limit to offences punishable with imprisonment for a term of not less than 10 years, the Sanhita replaces this with imprisonment for a term of 10 years or more. This change addresses the confusion created by the Supreme Court's interpretation in Rakesh Kumar Paul case. In the Rakesh Kumar Paul case, a 3-judge bench majority held that not less than in the CRPC must be given its natural meaning, implying a minimum threshold of 10 years imprisonment. Consequently, for offences with a minimum sentence less than 10 years, but a maximum not amounting to death or life imprisonment, the accused was entitled to default bail after 60 days. The Sanhita's new wording removes this ambiguity. Under Section 187 Clause 3, the 90-day period applies to any offence where the maximum punishment is 10 years or more, regardless of the minimum sentence. This change simplifies the application of the law and potentially extends the investigation period for a broader range of offences. Another significant change relates to house arrest. In Gautam Navlakha case, the Supreme Court had allowed house arrest to be considered as custody under Section 167 of the CRPC, with the period counting towards the 90 or 60 days detention limit. However, the second proviso to Section 187 Clause 5 of the Sanhita explicitly prohibits this practice. The Sanhita states that detention can only occur in a police station under police custody, in prison under judicial custody, or in a place declared as a prison by the central or state government. The sole exception is for girl children, who may be detained in a remand home or recognized social institution. This change effectively overturns the Gautam Navlakha decision and standardizes the places of detention for accused persons during investigation. In conclusion, these modifications to the law on default bail aims to clarify procedural aspects, potentially impact the rights of accused persons, and set clear guidelines for investigating agencies and courts in matters of custody and bail during criminal investigations. If you found this video helpful, please like and share it with others. Subscribe to our channel for more legal insights.